Hello, it's Semsettin Karahan from Zanoply. I received quite a few questions from Instagram, so I thought I'd create a video series to try and help best answer those questions. If we have a look at the first question, which is from Chris Ingram, when you going to do a Q&A, bud? I'm doing one now, thank you very much. Interested to hear more about your world, including timelines from planning to application to approval. First of all, great question, Chris. If we break it down, a planning application should take between 6 and 8 weeks. When you submit a planning application, it takes on average 1 week for the local planning authority to validate your documents. There has been cases where it's much quicker, but on average it takes a week. Once it's been validated, it enters the neighborhood consultation period, which is 21 days. This allows your immediate neighbors, depending on your planning application, to submit a comment, either supporting or neutral or even objecting against your proposal. After that, all in all, it should take between 6 or 8 weeks to get a decision. Hopefully that was helpful. If we have a look at the second question, it's from Liam Smith. Is planning permission required if I replaced a flat roof with a pitched roof? Another great question, Liam. It's a very common question that I get quite a lot. If the existing single-story rear extension falls within permitted development rights, and if your site benefits from permitted development rights, the answer is yes. A few parameters that you need to comply with, for example, the maximum overall height is 4 meters to the highest point of your single-story rear extension, and it's 3 meters up until the eaves. As long as it checks all 3 of those boxes, then you should be okay. However, it's always best practice to simply apply with a lawful development certificate, existing or proposed use subject to your circumstance, to regularize the development before you start works, or a prior notification application if it's between 3 and 6 meters, again, subject to your site and subject to your specific circumstance. Thank you. We've got another question from Liam Smith. Would I need planning permission if I built above a existing single story extension? Another great question, another commonly asked question, Liam, so thank you very much. Hopefully it will help a lot more people. In short, yes. A single story rear extension subject to your site and subject to the proposal, it should benefit from permitted development rights. A double story rear extension, it does not benefit from permitted development rights, and you can apply for it using a house order application subject to your site. A few parameters that you need to look out for example, it should not consume more than half the width of the rear elevation of the existing building. There should be at least a 7-meter distance from the proposed rear elevation of your double-story rear extension and your existing boundary. Of course, there's proposed materials matching the existing building, to name just a few of the policies that you need to comply with. Thank you. The fourth question is from Barry Ria. What changes have you seen and how the LPAs have reacted to COVID-19? Excellent question, very relevant. Of course, COVID-19 has affected many businesses, unfortunately, and many industries. So personally, I'm wishing the best to everyone. In short, there has been an impact in planning legislation from a commercial and a residential standpoint. Commercially, there's been the introduction of use classes with the hopes to promote the repurposing of a commercial premise under permitted development rights to help adapt to the current changes. And from a residential property standpoint, there's been the introduction of permitted development rights for an upward extension. For example, if it's a single-story building under permitted development rights subject to your site, you should be able to apply for an additional story. If you have a minimum of 2 stories, you should be able to apply for up to 2 stories under permitted development rights. Of course, complying with all of the policies set forth, such as if it's a terrace building, you can't go above the existing ridgeline by 3.5 meters. If it's a detached building, it's 7 meters, overall 18 meters, just to name a few. The other aspect that I've seen an impact in the industry is the response time with case officers. Usually there's 2 ways to contact a case officer. It's either through email or either through telephone. What I found is now when you are calling the local authority, they have adopted a callback service, which is usually between 24 and 48 hours, as opposed to internally transferring you so you can instantly speak to a case officer. Before COVID-19, this procedure was already in place within local authorities such as the London Borough of Ealing. They've got a 48-hour callback service, but now from personal experience, I've seen it's become more common practice across all boroughs. Additionally, I've seen an impact in response time for pre-planning applications. Depending on the scope of work, then naturally it can take between 15 and 20 working days, subject to your local planning authority. But now I've seen there's been a slight delay on average of at least 1 week. Again, this is from my personal experience and within the boroughs that I personally dealt with during the COVID-19 pandemic. Hopefully that was helpful. Thank you. And the fifth question from Farshad Dabeshkhoy, one of our clients. Best way to deal with difficult people at the council planning team? Excellent question, Fash. I completely understand that it can be frustrating, but it's very important to always refer back to your facts and your planning policies. If we take a back step, how you start is always how you finish. So if you start prepared, start well, you finish prepared and finish well with hopefully a positive result. For example, before we even accept the project, we conduct an assessment just to make sure that it's viable in principle and what are the key constraints that we need to consider. Second, when we go into preparing the design, then of course it's prepared in accordance with the national and local policy. And now this design, before it's submitted, it's supported within the planning application by design access statement, heritage statement if needed. And again, that's referring to each component within the design that's supported by a planning policy. Once we submit, of course, it's starting a dialogue with the case officer. Start a dialogue, show them that you're there. If there's any revisions that are required, we're here to provide them. If there's an issue or a constraint, then again, we're here to propose a solution. And of course, before you even start that dialogue, you should have had a list of potential issues that can arise and a rebuttal for those issues. So when you're approaching a case officer, then you approach them with confidence, knowing that you've done the due diligence, you've done the preparation from your pre-vetting of a proposal to your planning compliant design, to your well-supported design with supporting documents, to a list of rebuttals that you've prepared. Once you've done that, always maintaining a level of professionalism, always referring to facts, always referring to planning policy, and pushing the conversation towards a solution creating environment. It's you, it's the professionals that are involved, and it's the case officer working as a team in order to achieve the best outcome. Think of a case officer as the gatekeeper between a street and a development. So of course they want to propose someone that's in keeping, and of course everyone wants to propose someone that's in keeping. So to start a proactive dialogue in order to reach a common ground is very important. And once you've done your preparation and you've done it well, then you should be able to enter that exchange in a confident manner and push for a positive result. And the last question we've got is from Rob Newton or statement. It's garage and outbuilding conversions to resi and ancillary flats/garden offices. Thank you very much for your statement, Rob. And it's a commonly asked question that I get often, and hopefully this segment will help a lot of people as well. Generally, a garage should fall under permitted development rights because it's classified as an outbuilding, subject to the position of this garage on your site. As long as it's behind the principal elevation, it may fall within those categories of permitted development rights. But to best explain this topic, I'd like to break it down to 3 parts. One is an outbuilding under permitted development rights. The second is an outbuilding being used as a summer house. And the third is an outbuilding being used as a self-contained unit. Number 1 is under permitted development rights. You should be able to apply using a lawful development certificate, proposed use, subject to it complying with permitted development rights. The use types that comply with permitted development rights are a home office, storage, enclosed swimming pool, home gym, and so on. The external parameters under permitted development rights are, for example, the maximum overall height is 2.5 meters if it falls within 2 meters of the boundary, and it's 4 meters in overall height if it falls away from 2 meters of the boundary. The proposed footprint can't exceed 50% of the curtilage of the site. That's all of the land behind front principal elevation. If it's a terrace building, naturally it's the rear garden. If it's a semi-detached or a detached building, it's the side passages and it's the rear garden. And of course, the curtilage, they use the existing extensions and outbuildings to be calculated within that calculation. The second is an outbuilding being used as a summer house. You should be able to use a household application to apply for it. Now, the difference between a summer house and a self-contained unit is the proposed internal amenities for each type of outbuilding. For a summer house, it shouldn't be independent. It should still be reliant on the existing host building. For example, if you omit the kitchen, then it allows for shared amenities between both structures, which is what the local authorities tend to prefer. And naturally, you should be able to apply under a household application, but again, this is a grey area within residential planning permission, and what differentiates the two is subjective. Third is an outbuilding being used as a self-contained unit. You should be able to apply with a full planning application, however, generally it's resisted. The reason why it's resisted because one, it's either being classified as backland development or is cramped living conditions or poor quality of living. The main reason being a self-contained unit that's independent from the host building will be assessed under the same criteria as a new build dwelling. Now, when it's assessed under the same criteria, naturally it is going to result in poor living conditions, because in most cases you won't be able to satisfy the internal and external amenity requirements proposed in a new build dwelling. For example, the internal amenity requirements for a one-bedroom unit, you would need 50 meters squared within Greater London. And in most cases, for an outbuilding, can you achieve the footprint that's required for a one-bedroom unit? If you can achieve that footprint, can you satisfy the external requirements for car parking, for outdoor garden space, for refuse storage, for cycle storage, subject to your local authority? So if you can't, that will unfortunately result in a refused planning application. Hopefully you found that helpful, and if you do have a question, I'll be posting a Q&A series on my Instagram profile at Semsettin Karahan every week. So feel free to post your question there, and the following week I'll create a video specifically for you, and hopefully it will help much more people. Thank you.